Counter-argument to that is obviously that arbitration acts as a release valve for the courts, and it can, in fact, help achieve the outcome that Dickens was pushing for in Bleak House to improve the efficiency of the judicial system.
Behind Lord Campbell's decision to support arbitration. And in the quote that I read out before, he expressly referred to arbitration being acceptable as a matter of public policy because it resolved disputes economically and speedily. If we
There's not a lovely Alice in Wonderland situation where partners aren't interested in the same work and would like that that brilliant case that's coming in, but it can be more of an issue to manage in a large firm, in a partnership.
I think yes, it is more structured, it is more formalistic in terms of approving those things, but it also brings with it, there are really fantastic education programs.
The role of the ICC court, well, you pick it up in the ICC rules. I hope you've all got yourself a copy of the latest 2021 rules. Jo has one. I think she puts one under her pillow every night.
It just goes to show how important also the background work is to the court members, what the court members do in the committees. So
various levels of the courts actually where the parties agree that this can be introduced into evidence. And of course judicial notice is where the parties don't need to prove the facts. They are accepted by the court without the need for proof.
It was when the same evidence was being deployed in order to determine what specific remedy should be applied. That's when it became a little bit more controversial. And
the chicken or the egg, or whether one influenced the other. I think we're really talking about a process of fusion for transnational dispute.
Now, it should come as no surprise that as a procedural tool of the separability doctrine, competence also has its roots in civil law.
Leader, House of Lords judges, a very young Toby Landau, writing this report saying this is how the legislation needs to change.
You've agreed to arbitrate this, that's enforceable. The High Court 5-0 upheld that argument. Which was another one of my small occasional victories in court.
More of occasional, I know from.
Doesn't mean that you're automatically going to enforce all decisions. Where necessary, the courts have shown the level of sophistication and principle necessary to refuse enforcement of award where it is necessary.
Are advising a party that's arbitrating against a mainland party. Hong Kong has a unique advantage if you think that any interim measures would be needed.
The sort of complexity of energy transition type arbitrations coming up and the multiplicity of parties being involved in those dispute proceedings, it's likely that they'll be used a lot more in the future.
Competing interest between, the expeditious resolution of the dispute, which is the priority, but also the right of a party to seek interim.